How do you get a J1 waiver approved? This is one of the most common questions that I get, and it's a great question because it's not just showing mere separation, which is what the government likes to state if they issue a denial, that this is just mere separation. It doesn't rise to the level of exceptional hardship. That's what we're going to be talking about in this video. What is the difference between mere separation and the standard of exceptional hardship? That's really important to know because that makes the difference between getting an approval and not. Hi, my name is Ranchod. I'm an immigration lawyer and I've been practicing for over 20 years, and we have a focus in our law firm on J1 waivers. So we're going to be talking about that mere separation versus exceptional hardship. Now, as you know, the J1 waiver allows you to possibly bypass the 2-year home residency requirement. Let's talk about the 2-year home residency requirement before we dive into the distinctions between mere separation and exceptional hardship. The 2-year home country physical presence requirement is a significant aspect of the J1 visa program that applies to some J1 holders. And if you are one of those J1 holders that has a 2-year home residency requirement, one common type of waiver that you can apply for is an exceptional hardship waiver, and that's why in that type of waiver you need to demonstrate that form of exceptional hardship, or you can comply with the 2-year home residency requirement. But if you're watching this video, you probably don't want to do that, and you have a valid reason to. Now, the J1 exceptional hardship waiver is not the only type of waiver. There's the Conrad 30 waiver for physicians. There is the no objection waiver. In this video, we are going to be talking about the J1 exceptional hardship waiver. Let's look at the baseline, mere separation. When the government says, oh, this is mere separation, what that means is that this is what any family would experience if you were separated due to that physical separation. When a J1 holder is required to return to their home country, it does naturally cause some level of emotional and financial strain on the family. This baseline form of hardship is what USCIS considers not sufficient to rise to the level of exceptional hardship. U.S. immigration authorities expect that some degree of hardship is inevitable. Now let's look at some real world examples of what mere separation is. The emotional toll of being separated from your loved one. Although this is significant, it is by USCIS considered a normal consequence of the visa requirement. Now, I know that when you're separated from your family, this to you is not mere separation. I'm just talking about the legal standard. I acknowledge what you're going through. I know that in many cases when USCIS says, oh, it's mere separation, it is not mere separation. It's much more than that. Financial strain is another form. Financial difficulties resulting from the absence of your J1 holder can be challenging. They're also viewed as part of the expected hardship. Now, this is the challenge in crafting these legal arguments, is getting it beyond this baseline, and that's what we love to do at our office. So let's look at what is not just mere separation. What falls into the level of exceptional hardship? Let's look at some of those examples. Exceptional hardship is something that goes above and beyond the normal emotional and financial difficulties associated with separation. Let's look at those examples. Medical issues, if you're a U.S. citizen spouse or lawful permanent resident spouse or child, or U.S. citizen child has a medical condition that cannot be treated in the home country, this could constitute exceptional hardship. Educational disruption, if your child of a J1 visa holder would face significant educational setbacks due to the relocation, this could be considered exceptional hardship as well. In our application, since the standard is so high, we like to present as many forms of exceptional hardship as possible, because the more forms of hardship you have, when you stack them upon each other, it creates the narrative, it creates the story. We like to illustrate how this is going to create exceptional hardship for you. Psychological impact, severe psychological issues that could arise from the separation. Relocation, such as clinical depression or anxiety disorders, could also be grounds for exceptional hardship. And dangerous conditions, if the home country is experiencing political instability, war, or other dangerous conditions, this could significantly impact the safety and well-being of the U.S. citizen or lawful permanent resident spouse or child. Now, it's important to note that you have to demonstrate exceptional hardship if the qualifying relative was going to go to the home country with you, or if you're going to be separated. So in both situations, let's look at specific examples of exceptional hardship. Severe medical needs, a U.S. citizen spouse requiring ongoing cancer treatment that's not available in the J-1 visa holder's home countries. Special education needs, a child who requires special education services that would be disrupted or unavailable if they had to relocate. Some examples of this would be, for instance, if your child's autistic, they're not able to provide the support that they need to help your child with supporting your child with issues that come up with autism, or if your child has a learning disability. That was another type of case that we got approved. Those are some examples. Now, what I see missing in applications where prospective clients have come to consult with us to try to rehabilitate a denial or come to us with the RFE is the documentary evidence could be lacking. So it's not just enough to make these assertions. You have to back it up with the appropriate documentary evidence. So this could include medical records, psychological evaluations, financial documents, and other relevant information that can substantiate the claim. Also, detailed affidavits from family members, friends, and professionals such as doctors and therapists. The government really likes to see doctor's letters. This is really important, attesting to whatever medical issue you have. Understanding the difference between mere separation and exceptional hardship is essential for J-1 visa holders seeking an exceptional hardship waiver. I hope this video helped you make that distinction. And if you have questions, you can always reach out to us at 916-613-3553, or you can subscribe to just continue to get more updates and learn more. And by watching this video, you're bettering yourself. And by bettering yourself, you're bettering your family. And by bettering your family, you're bettering the world. Thank you. Bye for now.